please the court. I'm Alan Bedbeck. I'm here on behalf of the appellant, Stephen Heller, the father of the minor child, SB, in this matter. We are here on the appeal of a finding in the juvenile court granting legal custody to the child's aunt, Brianna Cody, over the motion and objection of Mr. Heller. It's the court's position, or the appellant's position, that the court erred, abused its discretion in awarding the child to Ms. Cody. I think that the evidence indicates the biggest problem that I have with the record is that it appears that Ms. Cody has been rewarded for undermining the parent-child relationship between the child and who, because we're posting these, I refer to as BC, or the child, and Mr. Heller, her father. They had a good relationship, an extended family relationship with the child and Mr. Heller and his father prior to this case being open. The case was not open as a result of anything that Mr. Heller had done. This was involving actions on the part of the child's mother. I believe Mr. Heller was not an eligible custodian at the start of the case. We may have been on probation, although I think for a while the child was placed with him and in the care of Mr. Heller's paramour. That changed and placement was made to the aunt, Ms. Cody. Throughout this case, if you read the record, there are 3 different hearings. Transcripts involve multiple dates on this motion. The magistrate at one point admonished Ms. Cody for failure to make visitation available to Mr. Heller. In response to that, almost immediately, and I think highly suspect, a charge of sexual abuse was brought in the general division against Mr. Heller, which obviously cut off his parental rights. The investigation of that claim proved to be unsubstantiated, and the investigating psychologist and counselor found that those accusations from the child were probably coached. The magistrate states very likely by someone, either Ms. Cody or someone in support of Ms. Cody, her paramour, the other most likely who also resided in the home, most likely option. In making the determination to place the child with Ms. Cody, the magistrate and the court gave weight to the child's opinion that she wanted to remain there, but it seems apparent from the timeline that that relationship with her own father was poisoned while those actions were pending, while the sexual abuse allegations were pending, the visitation was cut off completely. I think that there was a 3 to 4 month period where visitation was cut off. A small child, I think there was very little investigation in the record as to how those change of feelings may have occurred with the child. Obviously, the child did not testify. And I'm not saying that it would have been appropriate for her to do so, but I think that there is this appears to be a case where a bad actor is being rewarded for those actions, and the response and the findings of the magistrate and the trial court clearly are unreasonable in that they have handed a minor child to someone who and provided custody, and the responsibility for that child to someone who has shown no compunction for bringing exceptional allegations in order to accomplish what you want. I think has guided and manipulated a child into making such allegations. I think that is.
And also, counsel, is my recollection correct that the record reflects at the time of the hearing, the father was only permitted supervised visitation based on the child's defiance and desire that he not visit after this whole accusation happened.
And and I think that that is correct. I think that they were, that after the supervised visitation was limited based on again, everything that happened after that relationship. There was an attempt to begin visitation again. That visitation was attended by the aunt and her paramour, and the father found that to be disturbing. The child seemed to be reticent to engage with her father while those people were present. I think that there was, and then the caseworker's response to Mr. Heller's not feeling that was appropriate, not wanting to return to visits under those circumstances was simply to talk to his lawyer. There seemed to be very little regard for the position of Mr. Heller, that he was now facing someone who had apparently clearly manipulated his child, who had brought false allegations of criminal action against him. To ask him to be engaged in that seems to be, and to punish him for not taking part in that, I think is exceptional. And I would argue unreasonable point of abuse of discretion. That is, and I think that is the crux of this case, that, and this appeal, that I think Mr. Heller, he had been on probation at the start of the case. That probation terminated while this was pending. He was not, I will admit, he was not fully compliant with the case plan as presented to him. The caseworker indicated that he would have, the caseworker indicated that he would have recommended a return to Mr. Heller if he had engaged a little further in the case plan and had resumed those visits after the termination of the sexual abuse allegations. But under the circumstances, I'm not sure that that it was reasonable for him to resume those visits under the circumstances that the caseworker was imposing upon.
What's the record going to show how much interaction he had with his child prior to this case being started?
I think that you will find that he had a good relationship. I think he was not the custodial parent, but I think while this case was pending, he had a relationship. I think he and his extended family had regular visits. I think the record will reflect that the child had a relationship with both the father, Mr. Heller, and with relatives from Mr. Heller's family.
So he wasn't incarcerated during any of that time the child was born?
I do not believe he was incarcerated.
For some of it?
I think perhaps for some of it. I also think that he had attempted to maintain that relationship, and certainly his extended family had done so as well.
I guess one of the questions that I'm thinking about is, it is a little troubling in my mind, all these things that happened, obviously, with the alleged coaching of the child, and I guess for sexual and physical abuse allegations. So I could, if the state were here, I should call it the city, Sonoma County Child Services Board's attorney was here, I would question them about if you can coach a child to say that she's been sexually and physically abused, why can't you coach a child to say, I want to stay with my aunt?
And I would concur with that.
I'm just saying that's a question I would ask them if they're not here, unfortunately. However, I guess the point is, father also has not done what he needs to do. I mean, he had drug tests with cocaine in his system, had alcohol in his system, numerous things that father was not complying with this case plan in order to have the child reside with him. Okay, so I guess my point is, it sounds like neither one of them really should have the child. Legal custody was granted to aunt, but I'm not sure you're making a clear case that father should get the child back.
And I don't know that I guess my argument there is that I don't think there was a third alternative on the table. And I'm not asking that there should have been. And I am not, this would not be the first custody case where you were faced with making the best of for the better of two poor choices. I'm not saying that, but I'm not sure that in this case, that, and I agree that Mr. Heller could have helped his case by being more compliant on the case plan. There's no question of that. But that said, I'm not sure that this is as close a call as the magistrate and the trial judge found it to be. I think that the failure to submit to further drug testing after completing probation, and yes, he did have a positive test for alcohol after completing that earlier testing, and did not re-engage. I recognize that, but I think that action, and again, I'm not trying to minimize, although we as a culture put alcohol on a somewhat different stage, that there were the allegations. I think that pales compared to the allegations of coaching, the allegations of abusing the legal process to attain the goal, and being a person who would do that to a small child. I think that is where I think that I'm not saying that these are the best two choices in a vacuum. I mean, I think they're the only two choices available, and certainly better than what would have been an alternative of permanent custody. But that said, I don't know that it is as close a call as the magistrate made it out to be, and that Mr. Heller was, I think, clearly the better option in this case. And therefore, I would argue that the trial court and the magistrate abused their discretion and asked this court to overturn.
Thank you.
Thank you very much.